Welcome to this edition of the Rotary Reporter. I'm your host for the segment, Susan Wynn. Have you ever noticed that legislators always try to give new laws nice-sounding names? In fact, it seems the more onerous the bill, the more its informal title is a euphemism. Was the Affordable Care Act actually affordable? Do you really think this session's Rhode Island Board of Education Act will really result in better education for our kids? Neither did the Senate Committee on Education. That's why they killed it. Today, though, we're here to talk about the binding arbitration bill. It's been law for years. It was yet another gift to the public service unions that do so much for the office holders of the ruling class here in Little Rhodey. In essence, it requires that any contract negotiation for a new labor agreement for any public employees, either side may declare an impasse and seek binding arbitration. Sounds good. Let's settle things before there's a protracted court battle. Okay, if that's the case, why is it that the union side is the only one ever to call for mediation? Why is it there are only a handful of approved and certified advanced arbitrators in the state, 7 to be exact? Why is it that whenever a property taxpayer hears the term binding arbitration, he or she can be assured they're about to take it in the wallet? It turns out this out-of-court feature of the Ocean State labor negotiation process was put in place by union lobbyists, specifically because it gave their clients an extreme unfair advantage in their war against taxpayers. Here's how. Unions have full-time negotiating staffers who are expert at beating the part-time elected and hourly paid solicitors who usually represent you and me in these contests. These full-time negotiators know when a municipality sits down for binding arbitration, Rhode Island style, they are paying their legal staff by the hour. So the union side can easily estimate how much city or town money is currently shown on the meter, in that cash is X budget on some very precariously balanced books. So setting something simple like a workplace grievance is a piece of cake. As the city or town's costs are forecast to exceed the cash value of the original grievance, the taxpayers' reps have no choice but to settle. Labor contracts are a bit more complex, but the same basic arithmetic applies. Look, don't take my word for it. Here's what ex-town administrator and current state senator Gordon Rogers recently had to say on the subject.
But when you go to binding arbitration, you have to hire your lawyers, you have to hire your medical experts. It's just like going to a superior court case. You've got to treat it the same way. And that could cost $50,000 in legal fees and doctors and experts to win, or even if you lose, you could appeal it, and then you finally get to court where you're gonna win because you've got everything stacked. So they know it's gonna cost 50 grand.
So currently in Rhode Island, public service labor talks are not negotiations, but rather dictations. The public employees have been given an insurmountable position in any meeting. How does that make you feel? You and other hard-working, tax-paying men and women of our state are footing all the bills for the ever-escalating costs that stem from all of this. Are you angry that your pockets are being picked by the very structure put in place by the officials you elected? I mean, are you angry enough to remember in November